Please don't make the same mistake as this chap on TikTok whose comment I read yesterday, who didn't realise you can be charged with a drink driving offence without actually driving the car. Sounds a bit funny, but there are several different offences to do with drinking and driving that you might not be aware of, so hopefully you will be by the end of this video. But before we go on, if I could just ask you to take a moment to subscribe to my channel if you find this guidance useful, or if you think you might find it useful because you haven't watched it yet, but about 60% of you don't, and that's the only thing I really ask you to do. So please do that now, and now let's go on with the video. So let's look at some of these offences. Now, the reason people mistake these offences and misunderstand them is because drink driving offences is not necessarily driving. You can be in charge of a vehicle. And the second reason people confuse them is that you don't have to be over the prescribed limit. You could be unfit to drive through drink or drugs. Let's go into those in a bit more detail. So under Section 5 of the Road Traffic Act 1988, it is an offence to drive or be in charge of a vehicle with alcohol in your system above the prescribed limit. Now, one of these is a strict liability offence, meaning it doesn't matter whether you knew, and it doesn't matter whether you intended to, it only matters that you were driving if you are over the prescribed limit. So in other words, if you were driving the vehicle and you have alcohol in your system above the prescribed limit, it is a strict liability offence. You are guilty, whether you like it or not. There is no defence. The second offence under Section 5 is the in charge offence. You can be charged with being in charge of a vehicle with alcohol in your system above the concentration prescribed limit, and there is a defence to this. It's a narrow defence, which is not really always exercisable, but it depends on the circumstances, and I'll give you a couple of examples. In this chap's example over on TikTok, he was sitting in the driver's seat, the vehicle was parked up, he had the keys in his pocket, and he was found to be over the, I presume, found to be over the prescribed limit as opposed to the other offence, which I'll come back to in a moment. But in that scenario, he's in charge of the vehicle, definitively, really. He's in the driver's seat, the keys are in his pocket. He can't just say, no, officer, I'm not driving or I'm not in charge of the vehicle, because he clearly is. He's in the driver's seat. If he were in the passenger seat and there was another driver in the driver's seat, there may be a question as to whether they've just switched to fool the officers. If the officers saw him previously, then he can still raise this defence that he's not in charge of the vehicle at that moment in time, but that throws up all sorts of difficulties. Now, how about the scenario where the car is outside and he's in the pub and the keys are in his pocket then? Well, he's still in charge of the vehicle because in all likelihood, he's going to come out of the pub, get in the vehicle and drive away. Now, here's where the defence would be argued, and it may or may not succeed. In the pub scenario, unless he's got a pre-booked taxi or someone pre-arranged to pick him up, or the landlord knows that the vehicle's been left overnight and things like that, then he's going to struggle with the defence. The defence is available under subsection 2, which is, it is a defence for a person charged with this offence, being in charge, above, to prove that at the time that there's no likelihood of his driving the vehicle whilst the proportion of alcohol in his breath, blood or urine remained exceed the prescribed limit. So if there is no real likelihood of driving the vehicle, it is a defence to the charge of being drunk in charge of a vehicle. The pub example is probably not going to work in most circumstances, unless, as I say, you've driven to the pub, you've pre-arranged it, you've been sensible, you've pre-booked the taxi well ahead of time. You don't have a history of cancelling the taxis and things like that, because believe me, the police might, if they really want to follow this through, they might phone the taxi company and say, is this person known to you? We're making inquiries. Do they regularly book a taxi and cancel it at the last minute? Things like that. If they say, yes, he's a real pain, he books this taxi every Friday night and never follows through, then that's obviously going to be used against you. But if you were sensible and there's nothing like that involved and you've booked ahead, that might well be a defence. But usually that's going to be difficult. What about the scenario where you're in, a lot of the questions come about, you're in a camper van and you're on a caravan park or whatever, you're in a motor caravan or whatever. Then if you are definitively settled in for the evening and you're there for a week, 2 weeks, whatever, the police happen to find you asleep in the motor caravan and you're above the prescribed limit, then your defense clearly there, you would argue, is that there's no likelihood of you driving the vehicle. Your family is bunkered down for the night and you're going to sleep. So there's no likelihood of you driving the vehicle. That'd be particularly useful if there was a locked barrier to the park and you can only access it at certain hours of the day, things like that, so it's closed at 8 p.m. or 10 p.m. and you can't get out even if you wanted to. Then there's no real prospect of you driving the vehicle, things like that. But being over the prescribed limit and you are driving, that is a strict liability offence. There is no defence to it. But there is also another variety of this offence, which is being unfit to drive while under the influence of drink or drugs. This is Section 4 of the Road Traffic Act 1988. This refers to your ability to drive properly being impaired for the time that you were driving or in charge. So you can be driving whilst under the influence and your ability to drive is impaired, and you can be charged with being in charge of a vehicle whilst unfit through drink or drugs. Two very different offences. This one doesn't refer specifically to the prescribed limit, whereas Section 5 does. Now, there's another distinction between a Section 5.1a offence and a 5.1b offence. 1a being you are driving or attempting to drive, and 1b being you're in charge. Now, aside from the driving one being a strict liability offence, whereas the in charge has a defence to it, there is also a mandatory disqualification period for driving or attempting to drive, where it's a discretionary disqualification for being in charge of a vehicle. Now, why did all this confusion come about in the first place? Well, because there's a lot of discussion on social media just recently about driving whilst using a mobile phone. Because if you're driving using a mobile phone, even illuminating the screen, then you are guilty of an offence under Regulation 110. But there are arguments about being parked up, because if you're definitively parked up, then in my view, an officer is sort of wasting their time if they look into an offence while a vehicle is definitively parked up at the side of the road. Don't confuse that with being in stationary traffic. Very different. If you are definitively parked up at the side of the road, even to some extent if you've got the engine on, there are arguments for that, but I wouldn't risk my license with points on having the engine on or off and having a court decide. I would turn the engine off. If you're parked up at the side, I would turn the engine off. This discussion came up with regard to taxis. Now, that was a very narrow argument as to whether a taxi driver with the engine on at a taxi rank could even be guilty of this offence, because this offence for mobile phones can only be committed on a road. So the argument is a taxi rank a road? Now, to me, that's quite straightforward. If the taxi rank is incorporated into a road, then it's a road. If it's on a forecourt of some kind, it's arguably a road, but it's less definitive. And the same argument and debate came up with petrol forecourts. Now, most petrol forecourts, in my view, are going to be a road because most lead to and from a place. It is not a destination, whereas car parks generally are not a road. So cases that involved those were multi-story car parks and things like that, because it's a destination rather than a through place. So if you go onto it and go onto another place, if you're driving through, accessing one place from another, it's more likely to be a road. But all of those arguments came about to talk about the mobile phone offence that can be committed on a road, and whether you're parked, whether it's a road, and so on. But in this case, if you are parked up, just to be absolutely clear, if you are parked up, even if whether you're in the driver's seat, the passenger seat, or sleeping on the back seat, many people are prosecuted for being drunk in charge of a vehicle, even if you're sleeping on the back seat, because there is a likelihood that you think you're okay now and you get in the driver's seat and drive away. There is no real likelihood of you driving if you get out and you sleep somewhere else. Or, as the very narrow exception might be with a motorhome, if you're on a park, better if it's closed at night and your whole family is asleep, and, if the police happen upon your motorhome, your motor caravan, and you're all asleep, and you say, "What are you talking about, officer? We're all asleep. There's no likelihood of me driving." Then in most cases like that, a court is not likely to convict you because you're all asleep. But it's still an argument. It is an offence with a defence as against no offense being committed in the first place. So just be careful with that one. But driving, it is a strict liability offense. So please don't make that mistake like this chap on TikTok did. I don't know, obviously read some social media somewhere and drew a parallel line with the mobile phone offense and being parked and drink driving, which I say parallel line because they never meet. They don't cross over. There is no crossover between the mobile phone offense and being parked and drink driving. They are to be taken separately and analysed separately. So I hope you found that useful. If you do, please do subscribe. About 60% of you don't. It's the one thing I do ask you. But in the meantime, I hope you found that useful and thank you for watching.